Great. Hi, everyone. My name is Becca Kendis. I am the Reproductive Rights Fellow here at Case Western's Law School. And today we have an incredibly topical matter, given everything that's been going on in the news about medication abortion and mifepristone lately and changing by the minute. So we have two incredible experts with us today that I'm personally very excited to hear from. First with us in person, we have Farah Diaz-Teo, who is the Senior Counsel and Legal Director with If, When, How, who will be talking to us a bit about criminalization of people who self-manage their abortions. Also, although he's not on the screen at the moment, we also will have Greer Donnelly, who is a John E. Murray Faculty Scholar and a Professor of Law at the University of Pittsburgh Law School, who's going to be talking a little bit more about the FDA and its role in shaping abortion policy in the U.S. today. So again, both of these topics are very pressing at this moment, and I will let Farah take it away.
It's good to be here with y'all today. I'm assuming you're going to let that be. Yes, I'm Senior Counsel and Legal Director with If, When, How, Lawyering for Reproductive Justice. I'm supposed to be an interloper at these events because I'm not an academic. I'm kind of barely a researcher, although I think that nonprofits are generators of knowledge and that in mind. But it always feels a little bit like the College of Civil Engineering has asked a plumber to come in and they're like, how's it going down there? Which I totally respond, yeah, great, y'all. So my work really focuses on where the rubber meets the road, on what the impact of restrictions around abortions are on individuals and the way they are criminalized for exercising their reproductive self-determination. And to give you a little bit of a sense of sort of what the structure of the work that we do is. We're just focusing on the part of the work that I touch specifically. It encompasses a mix of litigation, policy advocacy, research, and direct legal services. So we do criminal defense and criminal defense support for people who are charged with crimes for having self-managed an abortion. We work to shift policy by introducing affirmative protection and fighting off bad proposals that would seek to criminalize people for ending pregnancies. I was extremely just delighted to be standing outside with a Dolan fabric and have somebody come and ask me to sign a petition to add language to the Ohio State Constitution. There's actually some big echoes of language that I've written myself, and I was like, I'm not. I did write that part. But so we do a mix of the affirmative and the defensive. We also do research. I'm going to discuss a little bit some of the research that I led with my primary investigator, Laura Huss, looking at all the cases in which people have been criminally prosecuted for either self-managing an abortion, helping someone else do so from the and then we run a legal helpline, the Repro Legal Helpline, where people can reach out with questions and to get legal advice, referrals for when you're facing the potential of being criminalized for having. And I think it's that piece, the piece of the sort of ongoing crisis response that I want to delve into a little bit here and encourage us as sort of technical interpreters of the law to think carefully about how we express what the law is and what it means, because that is extremely relevant for people. So the work that I do, because it pertains to criminalization, is, I would say in some ways, is Roe irrelevant, because arguments that somebody should be criminalized for having ended a pregnancy or done something that somebody alleges caused the end of a pregnancy isn't predicated on the notion that people have a constitutional right to bodily autonomy or anything else like that. It's actually on the much more basic premise that people can't be criminalized for things that aren't crimes under the law. And we're going to talk a little bit about like what that means and why there is a distinction between abortion being a crime and it being a crime for a person to do something that ends their pregnancy. To say Roe is irrelevant, though, I want to go back to something that was said earlier, the idea that Roe was never enough. And as somebody who is deeply informed by and rooted in the reproductive justice framework, that is a true fact. It is an article of faith for me. Roe was never enough. And also, as somebody who's selected the law as a tool to try to help people and to find in many ways that we're unable to do so now without Roe, I want to make sure that we're not mistaking the notion that the law is not enough. It's never been enough. Brown wasn't enough. Like no other, there has been no constitutional, no Supreme Court decision on its own that was enough. don't want to confuse that fact for the idea that rights are not really. And I want us to be able to envision a system of right and firm dignity and give people the resources they need to be able to live those lives with dignity. And to also recognize that negative rights, the lines that we draw around the individual and say that the state can't transgress those, are also important too. I don't want us to throw out the data with the family. So I'm going to start with some baseline understandings. And I understand that we're experts, mostly all of us. And I had noticed that there have been some sort of pervasive misunderstandings of the distinction between Roe being overturned, abortion being banned, and second-hand abortion being banned. And it's important for us to sort of disentangle those things because they have some very different meanings. So y'all know better than anybody else. Roe being overturned, what that means is essentially the invoking of the doctrine of Tacey's Baxies. And there not only is it not, there was a constitutionally protected right to an abortion, which doesn't automatically mean that abortion is unavailable in all the states. I think that's something that is not immediately clear to people. But instead what it did was trigger this race to the bottom. You can see this. I mean, these things, these beautiful Guttmacher Institute maps are like dead letters at the moment they're posted on the internet as states are raced to the hopper to put in new restrictions. But this is, you can see in many states, it is now a crime to perform an abortion, which is not the same thing as it being a crime to have an abortion or to do something to your own body that end a pregnancy. So in fact, look at the difference between this map and this one. And this is a map of the states in which it is a crime for a person to self-manage an abortion. It's super probably tiny for y'all, you can't see that. So the states are in purple, that's South Carolina and Nevada. Those are the two states that have laws in the books currently that criminalize self-managing an abortion. That's only two. Whoa. And in fact, the states that you see in teal and really tiny Delaware also are states that have repealed their bans on self-managed abortion just in the time that I've been presenting this particular slide. So interestingly, while the trend is that race to the bottom to make abortion as restricted as possible, there is also a trend towards decriminalization. And I'll just take a little side note here to say that is because it's still, even though we know that the end game is fetal personhood, the end game is to make sure that anybody who that makes their uterus inhospitable to a pregnancy is criminalized in some way. We know that that's the end game, and you're seeing a splintering tactics among abortion opponents as the hardline over the window shifters, the ones who call themselves the abortion abolitionists, are out there saying, yes, now is our moment, we're going to criminalize everybody. And the people who don't share that same perspective are a little bit uncomfortable with that. So we're in a moment of opportunity where we can take advantage and say, okay, if you, the 50 right to life groups that sign on to a letter saying that they oppose the criminalization of people who end their pregnancies, if that is truly what you believe, we need you to show up in your state houses now. This is the most, you want to advocate for a pro-life position. That pro-life position has to include not incarcerating people who end their pregnancies. So we were talking about the concept of procedure earlier, and I want to share a quote from one of my favorite books, Gregory Maguire's Wicked, in which Elva, the so-called Wicked Witch, says, "What is worse, suppressing the idea of personhood, or suppressing through torture and incarceration and starvation real living persons?" Something that I read that and sort of all my hair stood. I was like, yes, absolutely. So we see this trend of decriminalization of self-managed abortion. But the unfortunate thing, it's been a very long time as a lawyer to figure out, is that what the law says is often a very small part of whether or not a person is going to experience criminalization. What we found in the cases that we looked at, of course, the law can say one thing, but the factual circumstances of a person having ended a pregnancy can lead to just vast miscarriage of justice when a prosecutor on a mission decides they want to criminalize. So criminalization isn't just the law says something and then it is carried out in a straightforward way, but in fact, it's subject to a bunch of different factors. They're discriminatory, they're discretionary, and very often they're circumstantial. And so, even though it is only the law in 2 states that people can criminally punish pregnancy, We've seen in our research 61 people, 20 who are criminally prosecuted of managing an abortion or helping somebody else to do so. When I say helping somebody else to do so, this is generally the people who are generally swept in the net here are people who are their sisters, their friends, their loved ones. They're people for whom it is normal and automatic to try to help somebody who is coming to them not ready to be pregnant. I think that very often the opposition casts people who help others have abortion as being nefarious, or the sort of a lot of tropes about abortion providers, I think, are also cast upon people who help others in their pregnancies. And what it is actually is a very simple act of helping. And especially when we're talking about the context of abortion pills, is merely the sharing of medication. And I should pause for a moment and say, I've been talking about self-managed abortion, and I realize I haven't fully defined that term for you. So when I talk about self-managed abortion, I don't necessarily just mean the use of pharmaceutical pills. Mifepristone and misoprostol or misoprostol used on its own are extremely safe. They're extremely effective. Mifepristone was developed, the man who invented the molecule referred to it as the moral property of women and didn't want to patent it, right? Because of the recognition that this was going to be a safe and easy and private way for people to take control of their reproductive life. So we are fortunate to live in this room in which self-managing abortion is safer than it has ever been medically. And that said, people still continue to use other means. People continue to use herbal remedies and other types of remedies. People still continue to do acts of violence to their own bodies to end pregnancies. We don't want to stigmatize that, but we also don't want to encourage it. And this is why I speak with such urgency about these things, because we hear on our hotline the direct effects of the information that people get, and sort of like zeitgeisty interpretations of law and what they mean for real people. So when people hear things like this judge in Texas is making abortion pills illegal, we get calls from people with crochet hooks in their uteruses. I'm not joking. When we hear, when we say, as lawyers, even the Uber driver could get arrested for helping somebody have an abortion, we get calls from people in hospital beds who are being told by hospital administration that they have to wait until there are signs of sepsis for them to be able to complete a totally inevitable miscarriage they're in the midst of experience, because they are so afraid because the providers themselves are afraid of the condition. And when people hear abortion is illegal now in the state, we hear from them, they are being told by nurses, I know that the law changed in the state and I have to report this, and I don't know what to do, I don't know why, but I know that I have to report this. So our legal interpretations are back in an acting lawyer, the things that we say in public and state media, these things have real consequences for real people. So how do people get swept up in criminalization? So I would say very often we find that healthcare providers are a vector to criminalization. These are the findings from our research. You can see they're sort of all put together. Care providers, which include doctors, nurses, other emergency room personnel, are the plurality there. About 45% of the cases in which people that they were shunted that way by healthcare providers. Another large chunk are acquaintances, so people who were trusted with information, and that could be the partner in the pregnancy. It very often is a user. It could be just a family member or a friend with whom the individual shared that information, and then they turned them over to law enforcement. And then there were a substantial number where we didn't know, where there was some other way. And we're going to dig a little bit into these various pathways to criminalization. So first is the healthcare providers. And this is important. I think in my time looking at this, it has been the rarer case that healthcare providers were turning people over to law enforcement because they had some sort of political agenda themselves. There was certainly one case where that was apparent, and the OBGYN who called law enforcement was a very prominent member of the anti-choice OBGYN group, but that is generally not the case. And typically what we're hearing also from the healthcare providers themselves is pervasive confusion about what it is that what are they required to report, or what are they mandated to report, because many of them are mandatory reports, and what are they required to keep confidential under HIPAA and under state privacy laws. And the very sort of the quick answer to that is that even in places where it is considered a crime to perform an abortion, healthcare providers, they're not under an obligation to report every possible crime they could be. And I've certainly had conversations with healthcare providers who were like, but this person, but it is a crime in my state at the time this was in New York. It is a crime in my state for somebody to self-manage an abortion. Don't they have to report that? Like, do you have to report if your patient came in and they had broken their arm and attempted take candy out of the vending machine? Would you have to report that that's why their arm was broken? Because that's approximately the same level of offense in New York. It was at the time. It's been since repealed. You're like, oh yeah, I guess you're right. You don't have to report everything, but it's because of this abortion exceptionalism, this idea that abortion should be differently scrutinized and punished, and that there are some. My colleague Sarah Ainsworth calls it the aura of illegality. There is something just bad and wrong about abortion. We feel like we need to report it, but we don't know why. That sort of truthiness of the law. So it's not required. There is no state at this point that we know of in which it is required for a healthcare provider to report a patient for having self-managed abortion while self-managed abortion. Certainly, there are some states in which there are requirements that healthcare providers report certain types of injuries. There are states in which there are requirements that abortion have to be reported not to law enforcement but for public health reporting purposes to keep track of numbers of abortions, but mostly to harass abortion providers. In some of the states in which abortion complication reporting is required, they require reporting things that really have nothing to do with. So set that aside for a moment. And also, in the majority of the cases that we looked at where disclosure was made, it would be a HIPAA violation because it was not a disclosure made in response to a law enforcement request, but it was the other way around. It was a health system itself that turned people over to the legal system, which then opened the door for the unjust but lawful, put it that way, requests. And I think that is one of those things also that has been difficult for people to understand. That it is the acts of the healthcare providers themselves that essentially these proceedings could have not happened in the first place if a report hadn't been made. And so when we are able to clarify the law in the eyes of those first responders, what we'll call them, or in the eyes of health administrators, to let them know that those disclosures don't have to be made, then we can sort of forestall that problem of turning things over to law enforcement, and then when all you have is a camera, everything starts to look like a man. Because once law enforcement is involved, it generally triggers a set of reactions that are simply the reactions that we have to anybody who is being labeled as a criminal in our society, right? And what that means specific to these situations is bedside interrogations. Very often people are still under anesthesia from undergoing emergency surgeries. Having people, just their private lives interrogated and dug into in these moments of intimate crisis. And in many of these situations, people who have experienced the loss of a wanted pregnancy, really robbing them of the dignity of grief. Certainly one of the cases that would, yes, it was documented in our study. It was a woman who suffered the loss of a wanted pregnancy and kept the remains in the freezer while they were trying to figure out if they could get them cremated or how they could memorialize this loss. And because that had to be reported to the coroner, who's the law enforcement officer in that particular state. Then they got reported to police as a body in the freezer. Which the police came and broke down this family's door and treated them as criminals and asked them, why did you kill your baby when they were already in this state of grief. So anyway, by ensuring that what the law is and what the law means is clear, we can prevent a lot of harm on the front end. Oh, I have 5 minutes left. So many more slides. So another vector of criminalization is fetal remains. Certainly, I think we try to help people understand what their sort of constitutionally protected zones are, because people may not realize that when they dispose things in public sewers that then they can be found, and that often triggers a criminal investigation. We talked a little bit about disclosures to third parties, just somebody telling somebody who turns them over to law enforcement. But what I want to talk about are the things that we've seen that are not currently past criminalization. I think that these things have gotten really an outsized amount of airtime in media in a sort of Olympic level wrong tree barking exercise. So state approved telemedicine abortion. If you were in a state where you can get a telemedicine abortion, it is lawful for you to do so. Congratulations, you pass go, collect $200, you made it, you have a legal abortion, you were not going to be criminalized for that. Prosecutors are always doing the most, but we have not seen a single instance of somebody receiving an abortion that's lawful in the state in which they received it and being criminalized for doing so. We also haven't seen law enforcement prospecting. I think surely all of us are living our best Margaret Atwood dystopias right now, but we have not seen law enforcement effectively looking for people who are trying to end their pregnancies by setting up sting operations or anything like that. I mean, there's a lot of speculation about that. It's not there. We'll talk very briefly about what these cases actually look like. Information turned over by data companies and all of that. This hasn't happened because the tactics that they use law enforcement to build evidence are a lot more sort of workaday and period tracker apps. The great period tracker app panic of 2022, not a single case have we seen where the period tracker app was used, even when it had been extracted from somebody's cell phone data. And that part of that is because prosecutors just don't know very much about it. That's they're terrible cases. So I'll tell you a little bit about the things they do use. Text messages, not text messages that were like, that were gotten from the phone company, or text messages that were literally on the person's phone, which law enforcement trick people into handing over and trick them into unlocking by saying, we're gonna let you call a friend, please unlock your phone. If you're unlocking your phone, you've consented to this search, and then scanning through your phone, right? Also, internet searches, again, just looking literally at what is on a person's phone that they've been searching for, not subpoenaing Google. There's a lot going on there right now to try to keep Google from giving over information. Fantastic, that's great. I don't want Google to keep everything, being able to send everything that I Google. I don't know about y'all, but it hasn't been a part of these cases. Email receipts for pills, or just email receipts in the vernacular sense too, anything that people are emailing about, because it's on the devices that sees through very vanilla just searches and seizures, right? The things are there. Social media posts as well. It is even the sort of most podunk police department, they know how to do holds on your Facebook account so that you can't take down anything like that. That is extremely, you don't have to get again, like you don't have to send a whole subpoena to Facebook to get somebody's like private messages and all that, when very often people actually post about stuff. And much to my like tearing of hair on my part, like please don't on Instagram post about how you've been arrested for ordering pills from the service. It's not helpful. So I want to this is wisdom I want to share from my co-author to lead on this research. So y'all probably are aware of this Texas case in which a man has sued 3 people for allegedly helping his ex-wife end pregnancy. And one of the things that were used were text messages, a series of text messages that were shared back and forth between the women as they were going through the process. And people were like, oh my gosh, text messages. But when you look at the images that were included in the civil complaint, they are actually pictures of a phone with so you can actually see this guy's thumb. So he broke into her phone and took a picture of the messages that she sent. And an article came out recently and was like, and this just underscores the importance of using end-to-end encrypted software to communicate with documents. And my friend encryption doesn't mean you can't see it with your eyes. So I want you guys to remember that, like, yes, certainly use the disappearing messages, use the email that keeps their servers underneath the house. It's literally a thing. But abusers are going to be abusers, and they're going to break into your phone, and if they can find it, they can still see it with their eyes. And so what I'd like to tell people, I can say this because I do it from personal experience. It's like you don't have to do all those things. You should take the precautions you take. As a daughter of immigrants who has a boyfriend that her parents don't approve of, don't keep the stuff where people can find it. Know like what people can write through. Don't trust the information to anybody that you don't think is, that is going to turn it over to cops, and the abuser is always going to. So they trust, not tech. The tech is important, but the trust is fundamental. So just to leave you with a little bit of good news, so these are the states in which there have been introduced anti-criminalization measures, which is exciting. Measures say that people can't be criminalized or prosecuted for decisions they make about their bodies, their reproductive lives. And the Reproductive Law Helpline, the most important thing is that all of this is confusing. We're going to hear more about the FDA and all that, and it's changing on a day-to-day and hour-by-hour basis. And if even I'm not up on it, how can I expect the people who are just trying to live their life are able to do that? So the Reproductive Law Helpline is there to help them understand what the law is, what it means for them, and how they can keep themselves safe. Thank you.
I know there's plenty that you could put in, probably need a couple hours, but we're going to move on to Greer. Are you able to hear us?
Yep. Hi, everyone. Can you hear me?
Yes.
Good. Hi, everyone. Thank you so much for having me today and for inviting me to be a part of this great conversation. I want to particularly thank Jessie Hill for not only organizing the event, but also making accommodations for me. I just had a baby and it's very hard for me to travel. So I'm really grateful that she let me talk remotely. Given the news cycle, I don't think I need to spend any time selling the importance of the FDA's role in this new post-Roe era. FDA's role, of course, for abortion regulation comes from its regulation of drugs. In 2020 was the first year where more than 50% of abortions occurred with medication. Almost certainly this number is much higher today than it was in 2020, but that's the most recent data we have. And usually the data doesn't accurately capture people who self-manage abortion, so it's probably much higher than even kind of more current numbers would indicate. So in the United States, the kind of gold standard of medication abortion protocol for the last 23 years has been mifepristone followed by misoprostol, but only mifepristone. Mifepristone is the only FDA-approved drug that's FDA-approved to terminate a pregnancy. Miso is approved for ulcer treatment, but it's used off-label for a variety of obstetric uses, including miscarriage management, inducing labor, and other things. Miffy is also used off-label for miscarriage management, but it is the only drug that's approved to terminate a pregnancy. And almost certainly because of that on-label indication for abortion, it has been targeted for special treatment, not only with the FDA, but also, as we're seeing, with anti-abortion advocates. We know right now that both sides of the abortion debate understands the importance of abortion pills, right? There's an enormous amount of focus and pressure on abortion pills right now. And that's because pills offer many benefits. Among other things, it offers privacy. People can end a pregnancy in the privacy of their own home without having to go to a clinic where protesters might be, or just being in a public space that makes many people feel uncomfortable when it comes to abortion. Medication abortion is often cheaper, often much cheaper than procedural abortion. Many people feel that medication abortion is less invasive or more natural since it essentially induces a miscarriage. So pills offer many benefits. They are also a huge problem for the anti-abortion movement because pills can be easily put into someone's pocket and transported across state lines. They are infiltrating very easily into states that have abortion bans. And it's just proving in this kind of the post-Roe era is very different than the pre-Roe era because of medication abortion and because of its potential to ensure that people have access to abortion, even when the law prohibits abortion. So I'm going to talk, though, not about self-managed abortion. I'm going to talk really mainly about FDA regulation of abortion and some of the big battles coming that are, currently in the headlines, but also coming down the pike. So ever since the FDA approved mifepristone in 2000, it has regulated the drug very harshly. It originally used a regulatory pathway known as Subpart H to institute distribution limitations that were at the time, but still are very uncommon for many prescription drugs. So the FDA approved the drug, but said, "Hey, we're not going to let you just distribute the drug as normal prescription drugs. We're going to create limitations that make it harder for people to access it." This was converted into a REMS after Congress enacted the REMS program in 2007. But its original approval using Subpart H is obviously under big scrutiny right now with the Texas case. I'll get back to that in a second. But before the COVID pandemic, the FDA's REMS, right? So the special regulatory program that the FDA used to harshly regulate mifepristone included three major components. The first component was the patient agreement form. This is extra informed consent that essentially forces providers to do something that they are already required under tort law to do, which is provide informed consent to people getting an abortion, and then the patients actually have to sign a form. There's a certified provider requirement. So unlike most prescription drugs where a doctor or a nurse practitioner or whatever, the person's healthcare provider's license gives them the right to prescribe, for mifepristone, providers actually have to become certified. They have to attest that they could do certain things and sign a form with the drug sponsor to be able to prescribe. And the third part of the REMS before COVID was the in-person dispensing requirement. So the in-person dispensing requirement forced people to show up in person at a healthcare facility to essentially just pick up a drug. This was, really harmed a lot of the potential benefits of medication abortion because it essentially imposed on medication abortion all of the same burdens associated with in-person care. People had to travel to a clinic, essentially a clinic, to pick up a drug. Obviously before Dobbs, we had abortion deserts in this country, so that often that travel could be very extensive and time consuming and expensive for people. The lack of privacy I talked about earlier, people had to go to clinics to pick it up. It also cost more, right? It was more expensive. In-person care tends to be more expensive. All these things combined had a pretty significant impact on access. So once Biden took over, he immediately used enforcement discretion, something I'll talk about later, to remove or to temporarily halt its enforcement of the in-person dispensing requirement. The justification for that was the public health emergency of the COVID-19 pandemic. And certainly this was the right move. Forcing in-person care for something that has zero medical benefits and increasing people's risks of contracting COVID in the meantime was certainly a problem. And the FDA, under the Trump administration, had used enforcement discretion to halt the in-person dispensing requirements under other REMS programs, but refused to do so with MIFI. So when Biden took over, he said, we're going to use enforcement discretion to halt the in-person dispensing requirement for MIFI while we reconsider whether it's necessary at all. Thanks to the work of the crucial work of researchers who went in and started studying immediately the effects of not having an in-person dispensing requirement, we gathered data showing something that should have been obvious all along, that there was no medical benefits to forcing the in-person dispensing. And eventually, the Biden administration announced that it was going to remove the in-person dispensing requirement completely. This process was finalized in January of this year, where the Biden administration said, instead of removing the in-person dispensing requirement wholesale, we're going to replace it with a pharmacy certification requirement. So, as the law stands right now, that might change come 12:01 tonight. But as the law stands right now, the mifepristone REMS still has three components. The first is that patient agreement form I talked about. That's still there. Second is a certified provider requirement I mentioned. It's also still there. And the third is the new certified pharmacy requirement. I could honestly spend the rest of my time talking about why the certified pharmacy requirement was a bad decision and a very unfortunate outcome, even though the Biden administration, got a lot of good press for it. The results requirement are leading to all the news stories that you're hearing about regarding Walgreens and other pharmacies We still to this day don't have a single chain pharmacy that has successfully sought certification to dispense mifepristone. And the more I work with and talk to pharmacies, it's actually proving that this is going to be much harder than anyone thought. And so we'll see if pharmacies are able to overcome the burdens of the pharmacy certification requirement and actually start dispensing mifepristone. But that's, I want to spend the rest of my time talking about the cases in the news, and I'm happy to go through the pharmacy certification stuff in Q&A. So there are three major lawsuits that are impacting the FDA that have started right now. And the first two you've probably read about, the third I'll mention at the end. But I want to start with the lawsuit in Texas, right? So here we have anti-abortion groups that sued in Judge Kaczmarek's venue, arguing a few things that are super relevant. One, that the FDA's approval of mifepristone and subsequent actions regarding mifepristone were arbitrary and capricious because they use this regulatory pathway called Subpart H. The second is that the FDA couldn't approve mifepristone because it was illegal under the Comstock Act. So I'll start with the first and say the argument here is that the Subpart H regulations were, by their own text, limited to medications that could be used to treat serious diseases and illnesses. And using a kind of very textualist interpretation of those laws, they said the plaintiffs here argued that pregnancy is not an illness, and therefore the drug was improperly approved under Subpart H. So, just saying that right now, some of you might be thinking, oh, that sounds not so super unreasonable. But it's for those of us who study and teach FDA law, it was a very meritless and case from the get-go for a lot of reasons. The first reason is that the FDA has always interpreted the word illnesses to be interchangeable with conditions. And in fact, in the preamble to Subpart H, the agency used both interchangeably. The second is that when Congress codified Subpart H and turned it into the REMS program, it explicitly included the word conditions. Why? Because Congress wanted to make sure that mifepristone particularly was going to be under the REMS program, right? Congress was seriously aware of mifepristone, and one of the benefits of codifying and creating the REMS program was to ensure that the abortion drug would remain overregulated. So this was actually debated by Congress. So the fact, and then third, when the FDA converted the Subpart H restrictions into a REMS, arguably it cured any sort of a defect that could have arisen from the original Subpart H approval, right? So this was a very meritless case. I mean, Food and Drug Law scholars wrote a brief that I was included on, showing all of the deficiencies in this reasoning. You've now seen the pharmaceutical industry weigh in, noting that if the Supreme Court and the Fifth Circuit, rubber stamp these ridiculous arguments, it has going to have pretty serious implications for pharmaceutical innovation much more broadly. This is, a seriously problematic holding. The Comstock ruling is perhaps, if maybe not as important related to this case, but is much more important kind of like more broadly. And other people have talked about Comstock already, but Comstock, right, is this ancient law that bans not only mailing abortion pills, but also, by the way, any instruments used for abortion, right? So many people talk about Comstock as like, oh, this could end medication abortion nationwide. But the truth is, if we have courts finding that Comstock is still good law, it has a potential to end all abortion nationwide, because every abortion provider that provides procedural abortion relies on interstate commerce to ship the implements of the instruments for those procedural abortions in the mail. So absent abortion providers coming up with kind of private ways of shipping, which of course they could do, but that would take time, Comstock coming back to life has very serious implications for abortion nationwide. So obviously we have Judge Kaczmarek. No one, people were raising the alarms about this case, even though it was meritless, because it was Judge Kaczmarek, and he came through for the anti-abortion movement as they expected he would, writing an opinion that was not only, kind of, as many legal scholars have called, bonkers, but also just like steeped in anti-abortion rhetoric, right? He showed his hands. He was trying to kind of play his part for that movement very obviously. But yesterday, or I guess it was late on Wednesday night, the Fifth Circuit came in. Judge Kaczmarek basically affirmed everything that the plaintiffs wanted, saying that his order would immediately stay the approval of mifepristone starting at 12:01 on Saturday, so basically midnight tonight, and that without any action by the FDA, the drug would just become unapproved in this country. We can talk about the implications of that later. But the Fifth Circuit, right, ultimately changed kind of the contours of that stay, saying that the challenges to the 2000 approval of mifepristone were time barred by the statute of limitations, but otherwise saying that all of the other agency action post 2016 was going to be stayed. So what does that mean, practically speaking? Well, it means we're going to return to the pre-2016 label for mifepristone and the pre-2016 REMS for mifepristone. Regarding the pre-2016 label, which only approved mifepristone through 7 weeks of pregnancy and included a different dosing, et cetera. In some ways, this is not the most important part of the ruling, or in many ways, it's not the most important part of the ruling, because of off-label prescribing is ubiquitous and uncontroversial. Already, right, even in 2015 and earlier times, providers were prescribing mifepristone off-label at that time, and even today, providers are prescribing mifepristone off-label through 12 weeks of pregnancy, even though it's only approved through 10 weeks of pregnancy. So in some ways, the label changes are less important, although in the brief filed by Danko, the sponsor of mifepristone, made clear some kind of hidden implication of this, which is that all of their products that they currently have, which includes the current label, would all of a sudden be misbranded. So Danko is taking the position that unless the Supreme Court intervenes, it's not going to be able to distribute its current product, because it's going to have to make new labels for everything to revert back to the old label before it can distribute. So that's very problematic. But in some sense, the worst part of the opinion is that we will go back to the pre-2016 REMS. This would mean that in the states where this order is it's going to take effect, I'll talk about the Washington case in a second. We will go back to in-person dispensing. We will go back to physician-only prescribing. And this is just going to have a really dramatic impact, right? There are many states this will impact them that have a lot of abortion providers, including California, New York, New Jersey, Massachusetts. And in those states, virtual clinics will have to shut down. Brick and mortar clinics will be even further overwhelmed. And only doctors will be able to prescribe mifepristone if this takes effect. So, my co-authors, David Cohen, Rachel Ray Boucher, and I have been arguing a lot. You've probably, if you're on Twitter, seen us say this a million times, that the FDA can, kind of avoid many of this parade of horribles if it uses enforcement discretion to not enforce the order. So this is very different from, many people in the media are saying that the FDA should ignore the order in Texas. This is enforcement discretion does not require the FDA to ignore the order in Texas at all. Actually, enforcement discretion only comes into play if the order in Texas takes effect, right? Because it's if mifepristone is reverted back to the old label, that in that case, the FDA would need to use enforcement discretion and say, hey, even though this is a technical violation of the law, we're not going to enforce the law in this context. Arguably, this is not only the right thing to do completely within FDA's normal practices, but also mandated by the other case that you guys have probably heard about in the news out of Washington State. And this case, I'll talk about the original challenge in a minute, but the kind of punchline is that in Washington state, the judge ordered the FDA to maintain the status quo regarding the availability of mifepristone, but only in the 17 states and District of Columbia, which were the parties in the lawsuit. So,
Like 3 minutes, so a couple minutes.
3 minutes.
Sorry.
Great. Okay. I'm almost done. So the court in Washington clarified that this would require the FDA to only enforce the 2023 REMS in those 17 states. So arguably, or I am arguing that the only possible way for the FDA to comply with both the Texas and the Washington case would be for it to exercise enforcement discretion nationwide, actually. To ensure that the 2023 REMS is what it will, that's how it will enforce the statute, and also save Danko from some of the concerns they raised in their brief that regarding the misbranding rules. So the merits of the Washington lawsuit, I'll just say, are that those states were challenging the REMS, saying that kind of contrary to the plaintiff's argument in Texas, that actually the FDA has overregulated mifepristone and treated it much more harshly than the evidence deserves. And we haven't seen the judge weigh in on those particular concerns yet, but that will come down later. And then finally, I'll just mention, because it's totally getting lost in a lot of the media, that there is kind of a third effort regarding the FDA, that a few lawsuits, one in West Virginia and one in North Carolina, concern FDA's preemption of state abortion laws. So the issue raised here is whether or not the FDA's regulation of mifepristone actually means that states cannot overregulate it or ban it. And this provides a really important novel legal theory to try to restore access to medication abortion in states with abortion bans by saying, hey, states, you cannot criminalize the sale, use, marketing of medication abortion that is done according to the FDA label. Given that the vast majority of abortions in this country happen before 10 weeks of pregnancy, this would be kind of the enormous loophole in every state's abortion ban, and provide some important relief from the kind of horrors of Dobbs. So I'll stop there, and I'm happy to answer any questions. Thanks again.